I'm David Glazer.
And I'm Katie Ilton.
We're going to walk you through the most common unnecessary refunds we go through. Not many announcements, but just a couple. So first, our next webinar is on November 14th. David Waits and a colleague, I think Teresa Thompson, are going to be talking about Me Too related issues. So we'll go off of health law a little bit and more into the employment realm for that one. Then on 12/12, we'll have our annual Medicare fee schedule and other new stuff for 2019, including possibly a little summary of the opioid bill and other new developments. Otherwise, I'll just wish you well. I don't know, are you feeling 210s today?
Oh, yes. I think, yes, this presentation will be at 10.
Yeah, so it's
on this October 10th.
Right, so I like 10-10. All right.
But you can tell us exactly what you think about the rating in the survey.
In the survey, we'll mention the survey again at the end. Last thing, if let's say someone walks into your office in the middle of this and you need to go, hopefully you don't, I just want to put out a word. I'm bummed about the people who have to deal with Hurricane Michael, but if someone walks into your office and interrupts you, in 2 days, you will get a link that will let you listen to this on tape. All right, let's dive in. So we're going to talk about when you need to refund under Medicare, Medicaid, and everyone else. We're going to do the first part of that, kind of early on. Then we'll talk about the definition of an overpayment. That's actually going to be somewhat meaty because it answers the question for Medicare of when you need to refund. And then we're going to go through the examples. These are the things we run into all of the time. The last example will be, if it isn't written, it wasn't done. That's kind of at the end, because I know a bunch of you guys have heard us talk about that one before, so you can sign off if you want before we do that. So we'll do our wrap up and announcements before we get to that. All right. So when, if you do refund, who do you refund to?
This is actually, I think, an easy question to answer, but I was recently at a conference where there were a bunch of health lawyers, and I was surprised by their answers to these as opposed to our answer. So I think that a lot of people think that when you have a refund, you need to go straight to something like the OIG or the U.S. Attorney's Office, or if it's a Stark issue, go to do the self-referral disclosure protocol. And in fact, our advice 99.9% of the time is to refund by writing a check to the Medicare contractor for your region or the Medicaid agency if we're talking about Medicaid dollars. In only a very small circumstance or few circumstances would we actually be approaching the OIG about an issue.
Yeah, I think the only exception would be Stark,
sure.
Really, because Stark, the penalties for Stark are so draconian, there's a benefit to doing the self-disclosure protocol. In every other instance, really, well, no, if you think someone should be going to jail, maybe that's the other exception. But otherwise, refund to the contractor. That's all we got about that.
And that is rooted in the statute. If you note the report and return statute that is kind of at the basis of all of this today, it very clearly says notify the secretary or the state intermediary, the carrier, or the contractor. And so you can go right to the contractor. That's not being sneaky. Another note about timing here. So just remember, so the statute says that an overpayment has to be reported and returned 60 days after the overpayment, after the date on which the overpayment was identified, or the date that any corresponding cost report is due. David, what do we know about this cost reporting clause?
The cost reporting clause is a great mystery to most of us, I think. So we don't know. I mean, basically, it doesn't come up a lot, at least in my experience. I think the identification part of this is the big thing. And remember that quantification is what controls the 60-day rule. And we'll talk about this again in a little bit. And this isn't really about refunds. It's about when you don't refund. But just remember, you only have to refund 60 days after you've quantified your overpayment. Another quick thing about the statute and the statutory quirk, one of the questions is, do you have an affirmative duty to go search? The regulation says that the answer is yes, you do. The law defines the word knowing in the law, and then it never uses the word knowing. CMS says, well, since the law defines the term, it must have meant to use it. And so we're going to say that you have to, that's what creates an affirmative duty to go look for refunds. Just note, that's not clearly in the statute, right? So one of the things is there, do you have a duty to go do self-audit? The regulation says yes. There's a decent argument that regulation goes beyond the statute. And then kind of repeating what we've already talked about, the 60-day clock runs only when things are identified.
So does that mean if the compliance officer says we have an issue, at what point do we need to refund money right now?
Yeah, so I'd say you get probably 6 months to figure out whether or not you have a refund to do your due diligence. And then once you've figured out an amount of money at issue, you have to get the check cut within 60 days, is the way that one works. There is one other statute. I have the statute memorized. It's whoever has knowledge of an event affecting their initial right to any benefit or payment who conceals or fails to disclose the intent with an event with an intent to fraudulently secure the benefit is guilty of a felony. Even before the 60-day rule came out, this was there, and I would call this the kindergarten test, which is if you've got money and you know you're not supposed to have the money, you should refund it. This one's actually a felony. It's part of the civil monetary penalty statute, and it's just another principle, but I'd say a reasonable one. So Katie, I know one of the questions we get a lot is, what about the private payers? What do you do with private payers?
So very good question, and sort of the classic, it depends is the answer. Now, the very first place I'm going to go to is the contract you have with the private payer. That contract is going to have a couple key things in it. It might have a clause that says if you discover an error, you have to refund, and it might say when and why. But what I'm looking for specifically, if it isn't there, is how far back in terms of the length of time the private payer has under the contract to itself do audits and get money back that they determine is incorrect. And that is the timeline that I would work with. If I was dealing with a private pay issue, I would say, look, if they can only go back so far in the contract, then I would do the same with respect to refunding any issue that I determine is an overpayment.
And is there any time period you typically see in those?
It's typically 12 months. So that's hopefully what's also in your agreement.
And that's such a short compared to everything else.
Right. State law might have something about refunding money to private payers, but I think unlikely.
I don't see it much. And then the HIPAA part of this is interesting just because, remember, there is a HIPAA statute that creates health fraud applies to the private payers. It can be fraud to overbill a private payer. It can be in the same way that people often think that private payers are different than Medicare and Medicaid, and the penalties are way different. But as part of HIPAA in 1996, it's a felony to commit fraud. You got to be billing sort of intentionally wrong with a private payer. And then, it's interesting. I've seen a bunch of private payers say, gosh, bummer for you. You billed this thing wrong 18 months ago. Our timely filing limit is 12 months. So you're going to have to rebuild, but you can't rebuild because of the timely filing thing. So you get nothing. And that is a crock. Don't let anyone do this to you. If you have an overpayment situation where you billed A and you should have billed B, the refund is the difference between the two. You don't have a legal duty to rebill. Or I could actually understand a contractor saying they want the code to be right and they want you to rebill. That's fine. But if they try to assert you can't rebill because of timely filing, the overpayment is the difference. I think that's really, really, really clear.
I think the takeaway on private pay is really don't assume they're just like the government in that you might arguably have to go back 4 years. Assume your contract controls, and it probably has a shorter timeline.
Okay. So what is an overpayment? And this is the big legal question to determine whether you're going to have to refund or not. And so the law and the regulation are almost identical. In fact, they are identical with the exception that the law only talks about both Medicare and Medicaid. That's Title 18 is Medicare, Title 19 is Medicaid. And the regulation only deals with Medicare. So just as an FYI, there's not yet a regulation dealing with Medicaid overpayments. There's a law, not a regulation, all right? So an overpayment is money that you've received under Medicare or Medicaid, which after applicable reconciliation, you're not entitled to keep. So this raises a few questions, right? So you're not entitled to under the title is giant in our minds because we're going to talk in a little bit about the limits on how far back Medicare can go in reopening a claim. And we would say if Medicare can't take the money from you, you're entitled to the money under the statute and the regulation. and therefore there isn't an overpayment. So this is a really important point. So just think about this again. The definition of overpayment is money you're not entitled to. So we would say if the government can't take the money from you, you're entitled to it, and there's no overpayment. So we'll come back to that. Then, what does this phrase applicable reconciliation mean? I think it means you can offset underpayments, right? The CMS tries to say, nope, that's not what it means, that phrase only applies to cost reports. I don't think that's right. It talks in the preamble about how it applies to both parts A and B, and I'm not aware of any Part B cost reports, so that would make that section not make any sense. And it just seems logical. But you need to know CMS tries to say it's a cost report specific phrase. I think, and well, I don't know why I'm doing this, we think that you can offset underpayments in any situation where you're making a voluntary refund.
All right, so if I was to pick one concept to remember in walking away from this webinar, it is to adopt the mantra of manuals guidance can't limit coverage. Manuals guidance can't limit coverage. And so if you just take that and remember it every time you're presented with a potential refund, this will get you out of many of those situations. So what does that mean? We have actually three things that will help us to assert that guidance manual language can't limit coverage. So the first is the actual Medicare Act says that nothing other than an NCD, which is the National Coverage Determination, and there aren't very many of those, nothing other than the NCD may change benefits unless promulgated as a regulation. Talk about that in a minute. The other tool is the brand memo, which is relatively new but incredibly useful. So the Social Security Act, this is actually, we have to give credit to the American Hospital Association. They've brought a lawsuit, and I'm trying to remember the actual issue, but they brought a lawsuit against CMS for basically getting money back that was based on the fact that the claims didn't comply with guidance or Medicare manual language. And they, very helpfully to all of us, pointed out that the actual statute says that in paragraph 2, no rule, requirement, or other statement of policy, for example, a manual, that establishes or changes a substantive legal standard governing the scope of benefits and other things shall take effect unless it's promulgated as a rule. So this is very helpful to say that nothing that isn't a regulation is going to be able to say whether or not you should get paid for something.
And I think one of the other lessons here is it helps to look like I did not know about this law for 20 years of my legal career, and it was in there. I'm a little embarrassed by that fact, but I'll own it.
So then just this past January, Rachel Brand, the Associate Attorney General, issued what is now endearingly referred to as the Brand Memo. And this is actually quite a helpful memo from the government. And basically what it says is, I call it guidance against guidance. So this memo basically prohibits DOJ from using guidance documents. So those Medicare manuals, MLN matters, anything that isn't a regulation in the CFR, from using those guidance documents to take an enforcement action against the provider or supplier.
Now, important wording thing. I was just writing a memo about this week, and I found myself saying new guidance issued in January, and then I realized that's a terrible thing to say because nothing changed January 25th, 2018. This was articulating a principle that we would have said is true for a long time because of the next slide.
That's right. So if you need even more in your arsenal, there are a few cases where the government itself has had said if the manuals are counter to the statutes and regulations, then you relying on them are doing so at your peril. And then there's another case that basically says manuals do not have the force and effect of law and are not accorded that weight in the adjudicatory process. These are government statements in the brief, and they're consistent with administrative law and the concept and the statute. So
if the government is willing to stand in front of a judge and say the manuals aren't binding, I'm going to live with that.
Yes, and I'm not going to refund.
I'm going to say I lost one of those cases, and we brought that case in no small part because we figured we couldn't lose. We'd either win on the substance or we would get the result we got, which was manuals aren't binding. So here is our first poll question, and bear with us here because we got to make sure that this comes out right. So the question for you guys is how far back must you go? And this is for Medicare. okay? Because the answer will be different for Medicaid, for example. How far back must you go? Forever? 10 years, 6 years, 5 years after the year in which payment was made. That's a weird answer. 4 years, 3 years, or 1 year. We didn't put 2 years in. I did this question. I didn't put 2 years in. Yes, I should have. All right.
That's not the answer.
So hopefully the answers were, I'm going to be able to see the answers here so I can tell you what, I know what my answer is, but I'm waiting to see what the results are. Robert, can we close the poll?
Yeah.
And do I
share results?
All right. So our answers are, this is interesting. So we've got 2% at forever, 6% at 10 years, 50% say 6 years, 18% are 5 years after the year in which payment was made. I'm going to say some of those are our regular webinar listeners. 13% at 4 years, 8% at 3 years, and 4% at 1 year. And what's interesting about this, I will say, is that 50% of the people, so basically, I think that there are two answers that basically between them about 31% of the people got that it might be right. I think there's a cogent argument for 5 years after the year in which payment was made. There's a cogent argument for 4 years. I would say every other option on here is clearly wrong.
About 3 years in the rack.
Well, the rack can only go back 3 years, but I would say, so you're right about that, but I would say, if a rack went after me for 3 years, I'd worry about having to go back that extra year. Now, just a quick note, because I don't think we put a slide on here for Medicaid. The answer for Medicaid is state by state. New York says forever. Crazy, but true. In Minnesota, it's arguably forever. We've gotten them to go different. So we could spend a long time on how far back to go. We're going to do it pretty quickly. Here, click on it. Let's just try this again. All right, there we go. So there are a couple of statutory provisions in the Social Security Act, 1870 and 1879. And we've got the full text in the handouts. We're not going to go through the full text here. There'll be slides we'll be skipping. You can look at them on your own. We plunked them here. They're impossible to read. 1870 reads kind of like a statute of limitation, and that's the one that's got 5 years after the year in which payment was made. We'll come back to that. 1879 doesn't talk about that. It just talks about reasonable and necessary services. Neither talks about opening a claim. They just talk about recovery. Okay? 1870 says if you're without fault, the government can't recover money. 1879 says that if you did not and should not have known of an overpayment, you don't have to pay money back. Real world example there, you're a cardiology practice. The emergency room was doing ECGs on every single patient that comes in, every one of them, all right? They're not medically necessary, but you're in the outside cardiology practice and you don't know, you're without fault, you don't need to know. So remember that without fault thing, because that can save you a lot. Then there are these regulations. The regulations limit when the government can reopen a claim. And this goes back to the point Katie and I made early on. If the government can't take the money from you, there isn't an overpayment. So all the folks who said 6 years, they're focusing on the 60-day rule. Get that. It's logical. I understand why people are doing that. But that's a limit. You have to go back and refund an overpayment for 6 years. If there isn't an overpayment, you don't have to go back those 6 years. So we would assert that since the government can't do some of these things, there's no overpayment. So here's that 1870. I'm not going through it. You can read that on your own if you wish to have a headache. I will note that the 5 years changed as part of the fiscal cliff legislation in 2013. Until 2013, it was 3 years after the year in which payment was made. So if you've got an overpayment, we're almost done now with the periods where you should have overpayments still alive from 2013. But if you do, there's a shorter time period for claims from that window forward than today, okay? So how does 1870 work? You only look at the year in which payment was made. If payment was made January 4th, 2013, you count 5 years from that, 2014, 50. So you don't count 2013 at all. You go to the next year because it's years after payment was made. So you do 14, 15, 16, 17, and 18. You can recover through the end of 2018. If payment had just been made 5 days earlier, then you cut off a whole year on the government's ability to recoup money. A couple of weird things to note. First, it's payment, not date of service. So this isn't service driven, it's date of payment driven. And that whole 5-day change makes the 1 year change is insane. And so articulating this is hard because it's not a 5-year limit. It's 5 years after the year in which repayment was made. So super duper hard to describe. Okay, here's 1879. This is the, if you're without fault, the government can't recover money from you on a medical necessity situation. We're not going to go through that statute in detail. It's here for you to look at. Now we're going to go to crazy land for a moment. The government took the position in the 60-day rule that you are not allowed to make your own determination as to whether you're without fault, to which I would say they have no authority to do that. Just as an aside, when the government originally proposed a 10-year look back in the 60-day rule, we wrote a comment and said, you can't go back 10 years because of 1870 of the Social Security Act. That only lets you go back, then it was 3 years after the year in which payment was made. They changed from the 10 to 6. They never mentioned our comment. They just ignored it. And I think the reason they ignored it is because they can't address it and in a cogent way. All right, the regulations. So this is the regulation that says the contractor can only go back 1 year for any reason, 4 years for good cause, and then forever if there's fraud or similar fault. Now note that the government regulation defines similar fault broader than I would, because to me, fraud or similar fault is intent, and they define similar intent as including anything that you received that you should have known, basically, you're not legally entitled to. So that's a weird definition, but basically the government's not supposed to reopen a claim after 48 months, absent fraud or similar fault as defined here. So our argument in a nutshell, and now there's some manual language. I'm not going to read that either in detail, but it's just note that it's here, articulating the same principle that if you're without fault, and you get the presumption that you're without if it's more than 5 years after the year in which payment was made. And here is the limit on reopening, 48 months, absent fraud or similar fault, and you can read all of this stuff. Basically, it's setting up this 48-month test out of the manuals. So the regulation says 6 years, as many of you did. We think that that ignores an important fact, which is it's only 6 years, I would argue, if you're guilty of fraud or similar fault. If you're guilty of fraud or similar fault, you got to go back 6 years. If you are not guilty of fraud or similar fault, you have to go back 4 years. CMS doesn't buy that, and we're not trying to articulate that CMS accepts that. They would say if you get audited, this is the point Katie was making earlier, RAC can only go back 3 years. They would say if you're audited by a RAC and they go back 3 years, you have to go back further. They would say you have to go back 6 years. We would say you have to go back 4, unless there's fraud or similar fault. Okay? So also remember when you're thinking about your 6 years, it's not 6 years from the date you got the complaint. It's 6 years from when you're done quantifying everything, because that's when you've identified it, is when you've quantified it. So if you get a complaint January 1st and it takes you to July 1st to quantify it, you're going back 6 years from July 1st, not 6 years from January 1st. Interestingly, that starts to get a lot closer to the 5 years after the year in which payment was made. I may have covered too much too fast there, but in some ways I want to boil it down to you generally only need to go back 48 months unless there's fraud or similar fault. And certainly you shouldn't be ever, I think, going back more than 5 years after the year in which payment was made for Medicare. Medicaid, as we mentioned, whole nother ball game. All right, time for some case studies. Oh, I did that one already, so all right. I guess we should note, ultimately, I can see someone saying we want to go back 6 years because life's too short and we're not going to take the government on that. You can choose to do that. That's fine. Our goal here is to tell you this is what we think we could defend. And if you don't want to go back as far, you don't have to.
Do you think you have to go, if you go back 6 years in one circumstance, you have to go back 6 years in every circumstance?
This is such a good question, isn't it? You certainly, it's nice to be intellectually consistent, but I would say my answer is no. What's yours?
No, not categorically, no. I think you get to decide that because you do have the law on your side.
Yeah, and so
you can use discretion, and you can from a risk management.
And actually, that's something you might want to say in your letter too, right? You could say we think we only have to do this, but we're choosing to go back. Get the credit for it, which becomes an important point. we've had situations where our client does the good deed in refunds, and then the government comes in and tries to hit them with a 2x4 and go after them for more money. Doesn't happen often, but it's happened. And you might then want to be able to use your ability to go back and say, hey, we did more than we needed to here. And so I think that I would, if I were going back 6 years, I would say in my letter, we think we don't have to do it.
That being said, the vast majority of refund letters and refunds that I've helped facilitate when they were actual overpayments went back 4 years. And the check was sent and nobody ever heard a word.
In fact, vast majority. Yeah. I mean, like, I don't mean to be scaring people because I can count on one hand the times where it's gone south. All right, now is the part that gets really the fun part. We're going to do case studies.
And not of songs.
No songs will be heard in the making of the rest of this thing. So first, I have to tell a quick story on this next one. So we billed under the wrong position. All right. So this, I just had on Friday, I got a phone call. I have a client in California. They're doing a deal. The people who are buying them were super worried because they had billed under the wrong position. They hired an East Coast law firm. East Coast law firm told them they needed to refund more than a couple $100,000 because they billed under Dr. A and Dr. B provided the service. So they said refund $200,000 and you actually $300 almost, and you might have False Claims Act liability. And they charged them multiple thousands of dollars for that advice. This kills me because this is just wrong. This is a $500 question. This is what the Medicare Claims Processing Manual says, and it's really simple. An otherwise correct Medicare payment to an ineligible recipient under an assignment or other authorization. It's simple, but I can't read it. Doesn't
the hardest part.
It doesn't constitute a program overpayment. You are not overpaid when you bill under Dr. A and not Dr. B. It is not an overpayment. So can anything go wrong? Yes.
Yes, and I would say I wouldn't do it as a matter, a typical, from day to day thing, because what can happen is, in fact, you can have enrollment issues, right? So there is a whole other set of remedies that CMS has if they think you did something that they didn't like, and this would be one where they can take action against your enrollment, like, say it's abusive billing privileges if they think you're trying to get around something.
Or take away your ability to accept assignment, which is a giant bummer. So to finish my story, which I walked away from, so I told the client, you refunded that money voluntarily. You might want to appeal and get your money back. And they're like, we can do that? And yeah, as long as if you're refunding on specific claims and you do it fast enough, the answer is yes. It turned out they had 1 day left to do that. We did that for them. And on Friday, I got a call. They're getting their multiple hundreds of thousands of dollars back. So, which is interesting. It really validates this point, right? And we're doing it this is happening at the contractor level. We're not having to go up to the ALJ on the initial redetermination level. They're like, yeah, no, this is right. They didn't need to refund.
Which contractor? Some are better than others.
Yeah, I guess I'll name them because they did a nice job. It's Noridian. Noridian did this, and it was really classy. And actually, it was super. I really will name them because they were super classy on this. So Noridian gets the credit for this. And an East Coast law firm should be eating some major crow because they charged a boatload of money to give really crappy advice. So Katie has a totally hypothetical situation. This so never happens. We probably shouldn't even talk about it.
This never happens. The frantic call. The physician left, but she didn't sign her chart. We have to give the money back. Or we can't bill for the services, right? So usually it's we can't bill, but I've also gotten the panicked. We have to give the money back. I suspect this is a common occurrence, and I know you'll be surprised that physicians often don't sign charts. But so the question here is, does the physician have to sign documentation in order to get paid? Medicare CMS itself has said in a Q&A back several 1995, but hasn't been updated. It's same Q&A on E&M documentation. Is the physician's signature required on each page of documentation? No. The guidelines only state that the identity of the observer be legibly recorded. So we have to have some way to know who provided the service. Okay, great. Now, the Medicare Program Integrity Manual, in a misleading way, says that there are, in fact, signature requirements. So first things first, remember, we're in manual land.
Wait, so manuals are binding, aren't they, Katie?
Not in the guidance against guidance theory. No. as we talked about, there's an actual statute that says Medicare, that the guidance is not binding like manuals. So the first part of this manual says if the signature is missing from an order, then MAC will disregard the order during the review of the claim. David's going to talk about that, how that's incorrect.
Who's this MAX guy anyway?
The Medicare Administrative Contractor, so the carrier, I still refer to them. And even in that same section, it says if the signature is missing from any medical documentation, in fact, the contractor shall accept a signature attestation from the author of the medical record entry. So even the guidance isn't saying that we have to have the signature on the page in order to pay. Similarly, in the CERT request letters, you'll often see language about requesting a signature log in order to figure out who provided the service. So don't send back money if you didn't sign the chart.
And this should be common sense, right? You could add the signature at any point. The idea that a signature is what makes the difference on whether something gets paid or not is kind of wackadoo.
I wouldn't even say go find the physician who left unless you get a review and then get the attestation.
Yeah. I will add, I once in New Mexico had a client that got a $3 million overpayment because of a lack of signed chemo records. And as the contractor said, how do we know they were there? To which I'd flip that around. If it was signed, how do you know they were there? All right, now, Katie was talking about how that manual language is wrong. And that brings us to our next example. So we don't have written orders for our x-rays. So you got a refund, right? Because the program integrity manual says that if you are missing an order, you need to refund. Well, listen to Katie, always good advice. The manuals aren't binding. That's thing one. And then part of it is, here the manuals are extra not binding. And we know this. So this is the regulation for an independent diagnostic testing facility. And so we should put a star here. If we were in an independent diagnostic testing facility, you do need a written order, and it's in the regulation. And because it's in the regulation, I would be much more hesitant to refuse to refund in this situation. I'm worried about it here. Yeah, this is different. This is an order. This is a written order. This has nothing to do with signatures. This is a written order. And actually, you make an excellent point. The word signature does not appear here. If the order was written and not signed, we're good. So thanks, Katie, because I missed that. So, but here's what the preamble. So when a federal regulation comes out, they explain what's going on in text called the preamble. And the government said, hey, we're not imposing the same documentation requirement for written orders in physician offices because we think IDTFs are bastions of fraud, basically. So this is, at that point, CMS was called HCFA, the Healthcare Financing Administration. So we're putting a higher requirement on IDTFs than everyone else. The bottom line, in a physician clinic, you don't need a written order for a diagnostic test. If you don't need a written order, you certainly don't need to have it signed, right? But I see all kinds of people, and the contractor, or I'm sorry, let's try this again. CMS has forgotten about this language, and whoever wrote the program integrity manual needs to read this again. All right. Katie, you want to talk about
Sure.
The cops?
The cops. Two kinds of cops, which brings me to my next example. Mine is setting, mine the label. So, all right, conditions of participation. There are certainly regulations, so binding, that are called conditions of participation that require signatures in some instances and require orders. The important thing to know is that conditions of participation are not the same as conditions of payment. So what does that mean? Conditions of participation are all the rules you have to follow to participate in Medicare, to get the number, the bill, in order to be able to submit claims. This is all the Joint Commission accreditation stuff. Those don't govern whether the service you provide will be paid for. Those rules are called conditions of payment. And so accordingly, when you are dealing with someone who's saying you have a refund situation, you want to figure out whether the rule they're referring to, well, first of all, that they are actually referring to a regulation. And secondly, that the regulation is, in fact, a condition of payment. That's sometimes quite clear, sometimes unclear, but there are ways to figure it out.
Hey, Katie, I just want, you used the word rule there, and you said make sure it's a regulation. So I guess I hear you kind of saying you should use the word rule to refer to regulations. What would you call a manual?
I would call it guidance.
And I think this is something we should all get in the habit of doing, is drawing this distinction between laws and statutes, regulations and rules, same thing, and then manuals, guidance. I don't like to call it interpretation. I think manuals and guidance.
Yeah, right. I think that's right. Sub-regulatory guidance, kind of a fancy way for saying guidance, but means not regulatory guidance, not a regulation. Also, you can't have regulatory guidance because, anyway. So the Supreme Court Escobar case talks about the distinction between conditions of participation and conditions of payment. So that's extra helpful in the court saying they are different things. Some really useful language here to back up this position that their conditions of participation are not conditions of payment is in fact in the Program Integrity Manual. And I kind of forget about this language sometimes, but it can be used in many, many situations. Basically, they're saying CMS or contractors who are looking at provider compliance, they will not spend time looking at provider compliance with Medicare rules that do not affect Medicare payment. So the rules that don't affect payment are conditions of participation, conditions of coverage. That kind of sounds like payment rules, conditions of coverage. So don't be thrown off by that, because there may be a whole section of the regulations that is titled conditions of coverage, like there's one for portable x-rays. And when I first saw that, I thought, oh, great, we're sunk. This is a condition of payment. But in fact, they are quite different. Coverage is like participation rules or coding errors that don't change the Medicare payment amount. That is Medicare saying to its contractors, don't spend time worrying about them.
And before we go on from that one,
sure.
I'm going to say in a little bit, we're going to talk about dating errors, something I did a lot in high school. Well, I didn't have dates, but think of this language in this last sentence. We don't put it in again, but errors that don't change the Medicare payment amount, right?
That's going to come up. Yep.
So just keep that. If it's not an error that changes the Medicare payment amount, reassignment, same thing. So
right. So, David, can you talk about this state operations manual language?
Yeah, so there is language in the manual, and this is really just more backup of the same thing, that says in the event that you're terminated, you still get paid up until the time of your termination. So you can be out of compliance with the conditions of participation. They're throwing you out of the program, but that doesn't mean that you're going to lose the money. And so the Escobar case, it's not worth spending a lot of time on, but that was a case, terrible facts. It was a mental health facility in Massachusetts where they were using professionals that didn't have the right credentials to treat a woman who had a mental health condition, and she wound up committing suicide. And interesting, basically, instead of bringing a malpractice suit, or maybe in addition, the family sued the clinic for being out of compliance with the conditions of participation. And what the Supreme Court said ultimately is, the test is materiality. We're going to say, if the government knew what was going on, would they have paid the claim? And if the answer is yes, they would have paid the claim. You don't have a false claim. And if the answer is no, you do have a false claim. Now, remember, Escobar is a False Claims Act case. It doesn't answer our questions about overpayments. That's a different critter, but it's just worth knowing a little.
David, a question. If you don't meet the conditions of participation, how can payment be justified? This is a question that just came in.
Well, that's a good question. I mean, I guess the bottom line is, as long as you're enrolled in there are mechanisms to throw you out of Medicare, and that's kind of what this actually fits perfectly with this section. They can throw you out. Until they throw you out, you're entitled to get paid. And if you think about what some of them are, signature is a great example, right? We want you to sign. We want that in there. We're saying it's a rule, but they're kind of recognizing you still provided a service.
Here's an example. Every hospital, a patient has to be under the care of a physician. Maybe you have some unassigned patients who are there who aren't assigned yet to a physician. Does that mean that for every second that you don't have physicians assigned to a patient assigned to each physician, that all those services that you provided shouldn't be paid for the hospital to be paid? It just doesn't make sense. The department or CMS has decided what rules we need for you to follow as a threshold to participate in the program.
And it is worth saying the system actually is not perfect, but it's pretty fair all in all. And I think in compliance, we do our clients a disservice if we move beyond thinking big picture to thinking hyper-technicalities, right? I mean, if you called up and said, hey, David, we double billed for a bunch of services, I am not going to kind of come up with a way that you can keep that money, right? I think that's just crazy, right? We got paid for stuff we shouldn't do. But the flip of that, you shouldn't off of a misdotted I, or as I would say, a crossed I and dotted T. It doesn't make sense that money gets paid back there. Having a fair system makes some sense.
All right, so this is another mantra: mind the setting, mind the label, mind the setting, mind the label. So this is an example of where the government's language in the regulation or in the guidance is not helpful in terms of identifying the standards. So I've had clients come to us a few times who said, for example, oh my gosh, I think we need to refund money because we didn't meet all of the incident to requirements for these patients who were seen. And here we're talking about the incident to requirements that relate to office specific billing and services. And if I was not to ask if I didn't ask any further questions of the client, we would go down this road of talking about whether or not they met the incident to rules or regulations that apply in the office setting. In fact, I found that several instances of this panic call actually involved services provided in the hospital outpatient department, which CMS has unhelpfully also referred to as services that are furnished incident to a physician service. So it's the other type of incident to. So if you look closely at the regulations, the office setting incident to are services and supplies furnished incident to a physician's professional services and kinds that are commonly furnished in physicians' offices. And there are a number of different requirements that you have to meet in order to bill for those services, including a specific direct supervision requirement that the physician has to be in the office suite. And that's often the reason that we're not meeting the incident to rules in the office setting, is because the physician hasn't been in the office suite while the service was provided. Now, in the outpatient hospital setting, services that are incident to physician services rendered to outpatients are also incident to services, but they are entirely different bucket of services, and they have a different supervision requirement. In that instance, there doesn't have to be a physician who is in the office suite. And so incident to services that language is used to refer to both types of service, but they come with very distinct and different supervision and other requirements. So the lesson is, mind the setting you're in. Are you in the clinic or the hospital? And what is the label? And could the label be referred to as something else? So that's really almost a lesson to lawyer. Ask your clients all of those relevant questions.
And I'm thinking all these 80s songs are in my mind. Simple Minds, Bourgeois Tag, I don't mind at all. Okay. Hey, so we're getting a bunch of questions, and we're going to hold most of those for the end, but I'm going to mention two right now. One is, someone asked, what does IDTF and IPL stand for? IDTF, I hope I mentioned, was an independent diagnostic testing facility. I did not mention IPL, which is a term that is no longer used. It's an independent physiological lab. It's what they used to call lab back in the day, and then they realized IPL was dumb. I also just want to mention one other thing. We have tried something new with clients lately. It's not that new, it's been a couple of years. We're doing sort of an all the questions you can ask for a fixed fee. And as we get questions pouring in, I think people are often worried about the fees they pay on legal stuff. If you think it would be useful to be able to call up and ask us, a question like, is there a minimum amount that doesn't need to be refunded on an encounter? And have just like a flat, you're paying us X amount per month and we'll answer the questions for you quickly. We're doing that. We've put in our survey, if you're interested, you can mention that. We've done it with several clients. They love it. We love it. So enough of that. All right. This is going to be quick because A, I've talked about it in a bunch of prior speeches, and B, it's now getting old. But this is a marvelous example of how screwed up the world is and how important it is to think critically and be a contrarian. So in the old guidance situation, now we have the 2 midnight rule. Pre-2 midnight rule, the question was, what is a hospital admission? And all kinds of consultants around the world would tell you you needed to refund money if you didn't meet the interqual or Milliman guidelines, or if the person was there less than 24 hours. And I just want to take a second to look at what the manual said. And actually, this manual language wasn't changed until like 2017, even though the 2 midnight rule came into effect in 2013. So generally, a patient is considered an inpatient if formally admitted as an inpatient with the expectation he or she will remain at least overnight. Okay? So what's it take to be an inpatient? You have to expect to stay overnight, not actually stay, expect to stay overnight. Skip ahead 2 sentences. Physicians should use 24 hours as a benchmark. That isn't the same, except in Alaska in the winter north of the Arctic Circle. Overnight and 24 hours are different. Then the green sentence. The decision is a complex one only after you've considered a number of factors. There are at least 3 standards floating around here, none of which are Milliman and Interqual. And hospitals around the country literally refunded millions of dollars off of this. This drives us crazy. No one should have been cutting a check voluntarily on this. You should have been fighting tooth and nail because this isn't clear. And the fact that there were people out there coming in to, quote, audit you, unquote, and tell you you owed money back, I would call that malpractice. I think people shouldn't have been doing that. Where is Milliman in here? Where is Interqual in here? It's not. And so this is, you can tell I'm a little worked up. This is my rant about being a cynical consumer of advice, right? If you go to a conference and someone gets up and tells you you need to do something, don't take us at our word. Make us show you the rule. We're skipping some slides, but we're putting them in here so you're able to read and verify. So, Katie, what happens if UR says that something is not medically necessary? Oh, wait, this is me. I'm doing this one. So this is the treating physician rule. So you could answer it too. You know this as well as I do. But the treating physician rule, this is a magic bullet of sorts, which is under the Medicare statute. There are 2 quotes that you'll see in the next 2 slides. And they basically say, we defer to the judgment of the physician who treats the patient. And if reasonable people could differ, and the treating physician picks one of the reasonable courses, that carries the day. So anytime you're in a medical necessity fight, if it's close, if there's a cogent argument you can make, you should not be refunding, and you should fight any audit. But certainly, if like in the realm of reasonable, that was a terrible sentence. If your treatment was within the realm of reasonable, you do not need to refund. And in fact, just as an aside, this is more in the overpayment context. If the contractor comes in and they need to get a doctor to look at the claims, that's supposed to be enough to keep them from recouping the overpayment. That could apply in the refund context. If it's an ambiguous enough situation that you need to hire a physician consultant to review it, you could use this same language to say, it's not an overpayment because we needed to get a doctor to look at this. It's not an overpayment. We're going to educate going forward and not refund going backwards. So just something to think about.
I'm so excited because someone's asked this question of this hypothetical. Yeah. So the question is, have you defended 2 midnight inpatient case denials for lack of signature prior to discharge?
Have you, Katie?
I have not, and I hope you have not. So this example is the CMS actually being nice and saying, no, really, don't refund based on guidance, really. I am pained to think about the number of hospitals that have refunded money because their inpatient orders weren't signed prior to discharge. That was in guidance. It wasn't even in the manual. Well, it maybe eventually landed there. It was in like an FAQ, and then it migrated to a manual. And half the time people's signatures weren't there prior to discharge because sometimes these discharges were quick and, it's just hard to get people to do that. And I think there were both a lot of refunds and then also, even more so, a lot of contractor audits that were asking for money back based on the fact that the signature wasn't in the record prior to discharge. In fact, CMS, out of the goodness of its heart, it came out and said, look, we are aware that perfectly good medically necessary stays inpatient stays are being denied because of this technical issue with the signature missing prior to discharge. And in fact, this guidance came out just in the proposed IPPS rule, and in fact was finalized. And CMS said, we've concluded that if the hospital is operating in condition with the conditions of participation, that the medical review should focus on whether the admission was medically reasonable and necessary under the 2 midnight rule, and that an inadvertent signature should not affect the payment. And therefore, effective October 1, 9 days ago, CMS has changed the rule to actually remove anything about how the physician order has to be in the medical record in order to get paid for a 2 midnight stay. So they even went beyond removing that tricky guidance. They removed a whole chunk of the rule to say, so that there's nothing in there about how a physician order has to be in the medical record for a 2 midnight stay. So it's painful. So if you refunded because of you're missing a signature prior to discharge, and that's based on guidance, if you have refunded in the last 120 days, you should immediately appeal that refund to get your money back. And call us, we'll help you do it, because you will probably get it back. And this is a great example, and not very common, of the government saying, no, we really didn't mean for you to give us that money back.
And I will say 2 things. First, this free webinar just paid for a bunch of hospitals, right?
Yes.
And then there's a theme here, and this is self-interested, but this is a request I think Katie and I and our colleagues would make of you. Before you refund money, if it's more than $100, think about just a quick phone call. If you call Katie and say, hey, Katie, I just want to know, do we need to refund on this? That phone call is often literally 5 minutes. And that we have had, 6-minute phone calls that have saved clients $2 million. So something to keep in mind. All right, just to give you, so we've got about 10 minutes left before the top of the hour. We'll get through, I think, most of our examples before then, except if it isn't written, it wasn't done. That will go past the top of the hour. That's sort of our bonus feature. I'm going to do this one really quickly because it's not going to apply to a lot of people, but it's another good example. And the client who called me on this, it was a multi-million-dollar question. So this was a teaching hospital, and you've got the doctor working on residents on 3 cases. One's being opened, one's being closed, and one is in the key portion. And the person was looking at some language in the manuals that said if there are 3 concurrent procedures, basically you don't get paid. Now, the first hint is it's in the manuals, right? And if you've heard anything from Katie, don't refund off the manual. But here it was even clearer because the regulation in question, so first, even the manual said that the doctor didn't have to be there during opening and closing. And so in my mind, those don't count towards your 3, okay? But the regulation said the teaching physician doesn't have to be there during opening and close. So I would say, since the doctor doesn't have to be there during open and close, those don't count. And there was no duty to refund. And like I said, this was a multi-million-dollar question. And someone looked at that manual language and said refund. And to which we would say, A, it's just in the manuals, and B, it's just in the manuals and contradicted by the regulation. Okay?
This is a common question.
In fact, we even have one.
Yes, we have that here. What if you build under the wrong place of service, which has a different reimbursement amount?
Okay.
So, you have a bunch of claims that you realize it's the wrong place of service. And so there is going to be a payment differential. So, in fact, you may have been underpaid or maybe you were overpaid. Let's say you were overpaid. David, what would you do in that situation?
You're overpaid, and I would refund the money.
Refund the money. What if it was the wrong place of service, but the payment differential didn't make a difference?
I would either, I'm going to do a case by case. I'm either going to do nothing on that one, or I might write a letter to the contractor and tell them that I had the wrong place of service on the claim. It's going to depend a little bit on how wrong it was, like if it was and how wrong it was, I think.
So this is where there aren't clear regulations on the date should be the right date, but what happens if there's a wrong date, or what happens if there's a wrong place of service and there's not a payment differential? Common sense is a good way to go. Also, remember that program integrity manual language, which says specifically, let's reread it because it's good. the contractors are not supposed to focus on violations of conditions of participation or coverage or coding errors that do not change the Medicare payment amount. So that shouldn't be a lot of time that's taken up by the contractor or you, and it certainly shouldn't be a refund if there's no difference in the Medicare payment amount. Oh, here's another one that we get. But the LCD says we can't do it. So an LCD stands for local coverage determination. Importantly, not to be confused with national coverage determination. So national coverage determination has been adopted by CMS, and if we recall back to our statutory lesson, national coverage determinations, regulations, and laws can change coverage. But anything else, including local coverage determinations, which are just determinations that are issued by contractors, those can't change coverage. Also remember the brand memo. So, for example, if you have here's our statutory language. So the most recent example I have of this is an inpatient psych treatment plan was not signed by the physician. The regulation did not require any signature. The local coverage determination did require a signature, and compliance or someone in the hospital was saying we have to send back the money. And luckily they called, and we have the brand memo, we have all of this statute, and also there's some regulations that talk about how an LCD is not binding. So don't do it based on local coverage determination.
Okay, so what about the NCD goes too far? So you haven't met the NCD. So this is Katie found this language actually. I remember in this case, the first time I dealt with this was the implantable cardiac defibrillator case. The foreword for the National Coverage Determination Manual says that if you have an NCD, unless it specifically says something isn't covered, it still is. Basically, if it says it's covered in the following 5 situations, that doesn't mean it's covered only in the 5 situations. It means it's definitely covered in those 5. It doesn't exclude anything else unless it specifically says it's not covered. Unless there's a statement, it is not covered in the other situations, God, I'm really putting this poorly. You need an affirmative statement of non-coverage. A statement of coverage, if it says it's covered for the following 5 diagnoses, that doesn't mean that those are the only 5 diagnoses for which it's covered. It means it is covered for those 5 and others are not excluded. There we go. That was actually maybe a cogent way to put it. All right, Robert is going to go with our next poll.
All right, so this hypothetical is our certification is 1 day late. So let's say you have a 7-day, during the 7-day inpatient psych stay, the certification ideally would come on day 1, but it comes on day 3. Do you refund days 1 through 7 of the stay, the entire stay, or days 4 through 7?
We'll play a little music.
Little Jeopardy music.
You see, we should have the lyrics thing here. This would be perfect for the lyrics.
Jeopardy.
All right, let's close the poll.
See what we have. Close the poll. Okay, this is good. This is encouraging. So about 20% said days 1 through 7, the whole stay should be refunded, and then 80% are wise and said days 4 through 7. So in this situation, a condition of payment, a certification for the stay. Let's just assume, and it is in many cases, a condition of payment. Not always, so check that, depending on what stay you're looking at. But in an inpatient psych stay, it is a condition of payment. So you aren't able to rely on this, it's a condition of participation, so it's not a refund argument. But a lot of times, the next step is that people will take is, well, all the stays, we've got to send them all back. And don't think about when the certification came. If you did indeed get one, then you should really only have to refund the days that you didn't have the certification.
And this applies in the IRF context, which is an inpatient rehab facility. I think it can work in hospice. Basically, all the situations where you need a certification, once you get it, you're then okay.
Is our poll wrong? Should it have been days 1 through 3?
I don't know. It's too hard for me to think right now.
All right. Well, I think we got the concept. So only refund the days that you don't have the certification.
Yes, we had it backwards.
We had it backwards.
Totally backwards.
You guys got the right answer, and it was backwards.
We're not confident. Don't mind us.
Okay, so this is, I think, this is one that might take more than a 20-minute conversation, but still not 20 hours to figure out. This is the helpful enforcement position. So what happens if you have a clear condition of payment or statute saying you have to do something to get paid, but the government decides that they're not going to prioritize enforcement of that particular requirement? This is really tricky, but I am loath to just write a check in that situation. So the actual example is, so there's a statutory requirement that critical access hospitals have to get a physician certification that the individual is going to be discharged or expected to be discharged within 96 hours. That is a requirement for critical access hospital stays. However, in 2016, in the 2017 proposed rule, which became a final rule, CMS had this very interesting notice about its enforcement positions, basically saying we are sympathetic to this burden of getting these certifications, and as a result, we are going to tell our contractors that the lack of certification should be a low priority for medical record review, which means that critical access hospitals should not expect to receive medical records requests from the contractor to relate to this requirement. So how weird is that? You're not supposed to expect to get audited. Does that mean that you were overpaid? Technically, does that mean you should write a check? I don't know. I would probably think about sending a letter saying, hey, if you get the request for this, sending a letter saying, hey, we realize that this is an issue, but we also realize you're not enforcing this, so we're just not going to do anything. Let us know if you disagree.
There's no downside to that, right? What's the worst that happens is they say we want our money. Now, we know we're going past the top of the hour. What's going to happen? I'm going to do 2 more examples, and then we'll answer a couple of questions and move on to the challenging documentation denials. For people who have to sign off, I want to put in a plea. If you could fill out our survey, we're very interested in knowing about topics you would recommend and the other stuff. That'll come when you get the link for the recording of this. If you thought this was worthwhile and you want a colleague to listen to it, you can send it to them. They can listen to this for free. And all of our past webinars, not all, we go back, next month will be our 2006, we'll be starting our 13th year. But we've got about 8 years of a month. All right, new problem, got a refund. This is an incident 2 thing. All kinds of people think that if a patient has a new problem, that means you can't bill. They're wrong. The actual test, now I'm in the manuals here, but the manual happens to be also like the regulation. The requirement is that a doctor, whatever's happening has to be in the course of treatment, all right? So let's take a real world example. What's the difference between a new problem and something that's part of the course of treatment? It's chemotherapy. You're in the middle of chemotherapy, you get an infection. That's a new problem, but it's also part of the course of treatment. You can do things part of the course of treatment, incident 2. The test new problem language does not appear in any regulation. It does not appear in any manual. All right, last example. You've discovered you've got an excluded employee. You're toast, right? Like let's say you hired someone in March, you checked the exclusion list, they weren't on it. In December, you find out that they got excluded in mid-November. So you've got a refund on that last month worth of services, right? No. And this is back to remember, I think it was Katie who talked about without fault. Without fault will save you in a whole bunch of situations. And here, you checked to make sure the person wasn't excluded. They got excluded. No one told you you're without fault. Now, you're not without fault in perpetuity because the government expects you to check the list periodically. How often? They would say monthly. I think that's crazy.
They did just say 2 weeks ago in the conference there that monthly.
Monthly, yeah, that's their position.
Their position.
I think that's a little crazy. I would say every 6 months would be my thing. I don't know the answer. We're making this up, right? We don't know, but certainly not daily. And if you're without fault, if something about the situation tells you that this is really unfair, then you're probably without fault, and you should be thinking, we might have to refund. All right, let's do our questions, and then after the questions, we're going to come back to why, if it isn't written, it isn't done, isn't the law. I know many people have heard that, and we'll get off. So we'll do a couple questions. I will mention that our next webinar, don't forget, is the Me Too movement. That will be by our employment people, David Waits and a colleague, I think Teresa Thompson, on November 14th. And then on the December 12th, we will have the fee schedule thing. What other questions have we not answered here?
I got a question about the incident 2 in the hospital, and I just want to revisit it because I think I wasn't super clear. So there isn't both the statute for office services and hospital therapeutic services use the words incident 2. That's confusing because there are different supervision standards depending on the setting. So in incident 2 in the office setting, in order to bill incident 2, you have to have direct supervision, which means the physician you're billing for has to be present in the office suite. In the hospital outpatient department, in the therapeutic services setting, those services have to be provided under direct supervision, but the direct supervision doesn't have to have someone present in the office suite. So my point is, don't use incident 2 for both settings as the language. Use incident 2 in the clinic for the clinic setting and refer to outpatient therapeutic services as outpatient therapeutic services, and help your clients and your folks at your organization work that out, because then you will go to the right set of supervision rules.
CMS did not do us a favor.
They did not help us there.
If the Medicare manual is just guidance and there's no need to refund if we don't comply with it, why do we need to comply with the manuals? And that's a great question. And I think the short answer is you don't legally need to. Sometimes life is short. Like, you might choose to because life is short, right? And you may opt to just not pick that fight. But I guess the argument is you don't need to, is what we would say. I will say this, in that one of the cases I argued, I said to the judge, because the panel was pretty conservative, why do we pay taxpayer money to print these manuals if they don't mean anything? And I can't answer that question, actually. I don't have a good answer.
Really, the manuals are for the contractors.
That's an important point, yes.
And they're available for all of us to look at.
Yeah,
and we're expected.
But I don't have a good answer for this question. Is there a minimum amount that doesn't need to be refunded on an encounter, like less than $5 or $1? Well, if it's to the government, I would say the answer is probably no. But for patients, I'm a fan of the common sense test. I think no one's going to get mad. Draw the threshold at whatever you bill people. If you would bill them the amount if they owed you, you should probably refund it. If you wouldn't, you're probably okay. I know I once got a bill from a radiology group for an 18-cent service. That seemed kind of silly. And I wouldn't expect them to send me a check for 18 cents. I would be kind of annoyed if they did. Do you have any more? I think the next question I have is going to lead us into the next thing. So,
go for it.
What about poor and incomplete physician documentation? Would payment for a physician service be considered an overpayment? Well, funny you should ask. So this is something I hope regular listeners have heard this before. If it isn't written, it wasn't done is not the law. We'll do this pretty quickly. We have a whole webinar on this. It's in August of one year. I don't remember which year, August, I want to say 2015. So you can look at the whole thing on our website. But basically, Medicare pays you for what you do, generally, not what you document. Put a little asterisk there. There are explicit documentation requirements for anesthesia services and for teaching physician services that appear in the regulation. Otherwise, there generally is not a requirement that you document what you do. It's merely smart to. What the law says is there will be no payment made to a provider unless there has been furnished information to determine the amount due the provider. Now, what's the easiest way to do that? In the medical record. Could you do it via testimony? Yes. Could you do it via an affidavit? Yes. The burden under this statute is on the provider, and I don't like to use the word provider, the healthcare organization. Provider to me is a hospital or other Part A thing. Whoever billed for the service has a duty to prove that they have to furnish the information that they're getting paid properly. It'll be a pain in the butt to do it if you don't have good medical record documentation. It's going to cost you more, but documentation is not a condition precedent to payment, all right? And we know this in part because of a variety of this. In 1995, when the documentation guidelines came out, there were a bunch of questions. And first, just note the term, documentation guidelines. They're not called documentation requirements or documentation regulations. And CMS said the CPT assistant, which is the CPT assistant, is actually incorporated into the Medicare program. So if there's something in the CPT book or the CPT assistant, that's part of Medicare. And the CPT assistant said, these are guidelines, not a rule or law. Physicians need not modify their record-keeping practices. And then there was this Q&A. Katie cited part of this Q&A for signatures. First question, are these guidelines required? The answer, I put the color on it, but it's one word. No, you are not required to follow the guidelines. It's smart, it's nice, but they are guidance. You don't have to do it. And so if you've documented a 99214, documented a 99214 and billed a 99215, you do not have a one-level overpayment if you believe the doctor really did a 5 and just, failed to record the fact that the patients, had the pain for 2 months, and so you don't have duration, right? You're missing some element on there. And this makes sense for a whole bunch of reasons. One of them, think about this. If the note says the patient reports pain in her leg, are you going to give a location point for that? Many coders would because it says leg. Some coders won't because it doesn't specify right leg or left leg. And they would say that's not sufficient and we won't give a point for it. Now, I understand both of those positions, but it highlights how much discretion exists here. And that's another one of the reasons that you can't take this scoring system and call it science, because it ain't, which is one of the reasons that CMS is proposing getting rid of it. Whether they will or not, I think, is an interesting question. I vote no, they won't. But the way CMS views the guidelines is that in the event your documentation is missing, then they're going to look to see whether you really did the work. If the documentation is there, they'll close it out. Now, that's even a little, you can have, especially with a template, perfect documentation. That doesn't mean you did do the service. You can have a complete physical documented with a keystroke, and it doesn't mean it happened. So last 2 slides. So how are the guidelines used if I'm reviewed by the carrier? Well, if your documentation isn't sufficient, the carrier, in this case the contractor, is supposed to contact you for additional information. Is that what happens? No. It's what should happen. It's not what actually happens. And then, so how do you figure out if the service was done? Well, you ask people, right? I mean, the number one thing I'd look at, the number one data point I'd use, if I only could get one data point to determine where to shoot for overpayments and the like, on doctors would use RVU, productivity. If the doctor's productivity is believable, I believe that she did what she said she did. If the doctor's productivity is not believable, I don't believe he did what he said he did, right? And now I'll tell you about a real world case I worked on, a doctor with 30,000 RVUs. And I thought, no way on earth that doctor had 30,000 RVUs, until I sat with that doctor and watched him do his spiel. And it was really impressive, right? And he explained some of this. While shaking the patient's hand, he's feeling the skin, feeling whether it's warm and dry. He's looking at the person's gait. Are they standing upright? Looking to see if their breathing is labored. And I saw all of that and went, that's really, really impressive. At the end of the day, I was convinced he really did the work. So we went through this part pretty quickly. Like, if you have any questions about this, shoot Katie or me an email, and we can either answer them or we'll hook you up with this past webinar. I think so. We have a boatload of people on here, and they haven't signed off yet. Apparently, I think a lot of people have not heard this argument yet. We have no more songs, we promise. But I will put in a plug for Monitor Monday, actually, because I do a song every Monday on Monitor Monday. Come listen to us on Monitor Monday, and please fill out the evaluations because we would love more topics. We're good for November and December, but after that, we need some good topics. And if you are interested in all of the questions you can ask for a fixed fee.
Those are our favorite.
Yeah, let us know. Let Katie know. Let me know. And have a lovely evening. Happy 10th. Oh, don't be too tense today.
Haha. Take care.